All rise. The Court of Appeals, Division 1 is now in session.
Thank you. Be seated. Good morning.
Good morning.
For another few minutes, good morning. Now's the time set for oral argument in cause number 1CA-CV17-0769. Help me out.
TOURTILLOT.
TOURTILLOT, thank you. TOURTILLOT versus Yuma County. For everybody's information, these proceedings are being both audio and video recorded, so barring any problems with the equipment, you should be able to watch yourself on YouTube in a couple of weeks. Counsel, each side will be entitled to the customary 20 minutes. We would ask that you respect that time period. The timer located on the podium will let you know how much time you have left, and for the appellant's purposes, if you wish to reserve any portion of your 20 minutes for rebuttal, or I guess redirect or response, please let us know so we can avoid taking up all of your time. However, ultimately, reserving rebuttal time will be up to you in each of your capacities. We have reviewed the briefs and conferenced the case, so we are well aware of the facts and the issues that are attendant to the argument. We say that so that you can decide how you can best use the 20 minutes you have available to you. Counsel, when you each come to the podium, I would ask that you state your name and who you represent so we've got it on the record. And with that, the appellant may begin.
Thank you, Your Honor. My name is Michael Medina. I represent the TOURTILLOT plaintiffs. I'm also going to argue on behalf of the co-plaintiffs as well. I'd like to reserve 5 minutes for rebuttal. And with that, I'll get started. Wanted to talk to the court about the underlying decision and why Cole doesn't apply in this case. Specifically, in Cole, the City of Phoenix had the traffic, the SIGWAR criteria in place. In this case, while Yuma County had a traffic analysis study, in 2000 they also did a traffic study on this particular intersection. On the basis of that traffic study, several recommendations were made regarding the intersection, including the inclusion of a four-way stop, some different signals including warnings ahead of the stop sign. So this did not come about through the traffic analysis. This came about by a particular study. And what occurred was, after that, Mr. Perkins, the Yuma County traffic engineer, made some decisions based upon the traffic study, which were operational decisions. He didn't want to go through the four-way stop. So first of all, he asked that the study be revised and wanted to take an incremental approach to the intersection. That incremental approach included the installation of the flashing warning signs, and then eventually they also placed a sign that said cross traffic ahead does not stop. Those were all operational decisions, given that the county already, or the traffic study had already identified it as a intersection that needed improvement and that needed a four-way stop. And there's some disputes about the language of the traffic study and some of the confusion. It was rewritten and that sort of thing, and all those things occurred with the traffic study.
So, counsel, was the location identified by I guess, as a result of some study formulated by the county?
It was a study performed by Nicholas Engineering, as independent agency, and identified what occurred back at used to be a dirt road. They paved it. Yuma County was aware that there was some series of accidents that occurred there, and they had it analyzed in 1995. At that time, they decided it didn't warrant a four-way stop. Again, another analysis was done in 2000, and that time, under the traffic study, there were talks about that at that time it warranted a four-way stop.
So the distinction between Cole is this isn't about compiling a list of projects against the backdrop of a discrete universe of proceeds or money. This is an intersection that was identified, and what we're talking about here is from that point forward after it had been identified, and that is operational rather than budgetary.
Correct, and I think even Yuma County admitted that one of the countermeasures that they put into place cost more than the traffic sign, so it wasn't budgetary at all, a budgetary decision at all.
So, council, they had a plan, they had a program. They went out and looked at a particular intersection, and then recrafted the plan around the intersection. The study, they wanted an incremental. Yuma County wanted an incremental approach, so the study was redone to include that incremental approach. And
how many intersections did the study encompass?
I'm not aware of how many. I know there was a specific study done on that intersection.
Okay, so the study we're talking about encompassed one intersection.
Correct.
Is that right? Okay, thank you.
And I believe it's one of the appendices to the documents. In Cole, if you remember, the appellant brought up the issue of there were three intersections that the city of Phoenix didn't make the SIGWAR program, but they went ahead and put signals in, and the city used that. There were new developments. One was where the Mayo Clinic was, and that sort of thing. So in those cases, since the city couldn't escape liability if they negligently placed traffic signals or that sort of, or ignored the manual on uniform traffic control devices, simply because it went outside. It went outside the SIGWAR and recognized these special conditions for those intersections. The fact that they had a SIGWAR program wouldn't make the city of Phoenix absolutely immune in those circumstances. Some of the language in the some of the other things that the Yuma County didn't do was the last traffic study. Traffic volume study in that intersection was 8 to 10 years old, and one of the things that the study asked for was an updated traffic volume study. There used to be a primarily agriculture area. Yuma County knew that there was a lot of growth in that area, and based upon that, they should have done this updated traffic volume study. Some of the other issues were due to the high speed of that intersection. Given its rural nature, the traffic, the speed limit there was 50 miles an hour, and because of that, any collision at that intersection was unreasonably dangerous, just due to the speeds present at that intersection. Some of the other cases are the Almendarez case, and in that case, first of all, it's not a published decision, but that case is distinguishable because what the Mojave County had was, because this was a right-of-way and not a county-maintained street, they weren't allowed to, because of the source of the funds, they weren't allowed to improve that intersection or the right-of-way. And if you look at some of the language in there, that it makes it clear. If you look at footnote 2, it says, as the county has never included intersections of private easement roads with county-maintained roads in a study. So that shows that Almendaros is also distinguishable based upon those facts. The key case is Schauble and what occurred in that case when the school district decided to place a playground equipment at a school. Underneath, they placed the playground equipment, but they didn't put any protective cover under the playground equipment. And when one of the students was on the playground, he fell and shattered his arm. The court made it clear that the decision to put the playground equipment was entitled to immunity, but the negligence in choosing what playground equipment and what safety measures to take wasn't entitled to immunity. The Schauble court explained, by way of illustration, a decision by the district board to construct a playground at a school and allocate funds for that purpose would be a policy decision protected by immunity. Deciding what specific pieces of equipment to have on the playground would not be a policy decision, but rather would be an operational decision. And that's what occurred here. Given that the county of Yuma County recognized that they needed a four-way stop, the decision on what type of measures to take is not entitled to immunity. And that should be a question of fact. They can argue that Mr. Perkins used his sound engineering judgment and those sorts of things, but it's not entitled to immunity. And Schauble even talked about that. Among its defenses, the district would have the opportunity to prove to the jury that it had been reasonable in its installation and operation of playground equipment. So Yuma County, in this case, can argue to the jury whether it was reasonable this incremental approach it decided to take when it asked the drafters of the study to rewrite it and to include the incremental approach. A couple more points. Another thing from Cole is footnote 7. The court did not address the city's argument that every decision not to signalize an intersection constitutes fundamental policy making and is therefore immune even if based on negligent operation decisions or faulty data. So here we have a negligent decision in not making it a four-way stop and instead of choosing these incremental approaches. And therefore, Cole has not addressed that issue. The other thing that happened.
Leave it open, though?
Yeah.
I mean, if Cole didn't address the issue, might it not still be arguable that every time a city decides to do nothing, or a county decides to do nothing, it is immune?
Well, I think you have Galati and Goss that say if a county decides to do nothing, they're not entitled to immunity in those cases. They have to take at least make some affirmative decision to get
but if the
for that immunity.
I guess the argument might well be coming our way in the next few minutes. If there's an affirmative decision to do nothing, that immunity just automatically applies.
But in this case, Yuma County didn't decide to do nothing.
I understand.
Yeah.
I understand. But as we talk about these immunity cases, we always start with the background of coal. And if coal left open the possibility for even further expanded immunity, I just wonder what your view is on that.
I think they would have to show a basis for not doing nothing. They can't just, they're charged with safeguarding the public. They're the ones under Ryan, they need to make streets reasonably safe. So they
need to make streets reasonably safe when they build them.
Right.
But in Arizona, we have a lot of communities in which the streets were constructed a fairly long time ago, and then there was a massive increase in population that rendered those original designs probably less than ideal. Are you saying that there is an obligation on cities and counties to improve their roads to meet the rising demands of rising populations?
Well, I think under to keep them reasonably safe, there is that obligation for cities to do, and that's what.
Well, is the obligation to keep the streets reasonably safe or to make them reasonably safe? And I ask that because over time, safety standards have evolved, right? We learn more about safety. There are new things we can do to make things safer. Population increases. Vehicle requirements change over time. Is there an obligation on government to keep up with those things? Or could a government simply say, you know what, we prefer to be a low-tax jurisdiction. We're not going to raise the revenue to do all those things. We have streets that were good enough when we created them, they'll just have to do.
Well, if you go back to the original, your original, what you said about whether to fund those, they're entitled to immunity on whether to fund any road projects. But once they decide, that transforms from a legislative to a
no question.
operational.
Once they decide to fund a road project,
Right.
They have to do it in a non-negligent manner.
Right.
I don't think anyone would argue with that. But if they decide to simply do nothing because they'd rather do nothing, as a matter of policy and politics, the decision-making body of a county or city decides to do nothing to improve or keep up with the changing demands of the times. Isn't that what immunity is for? I mean, as counterintuitive as that may seem, isn't that what's most protected?
If it's a legislative decision, then it would be entitled to immunity in the beginning. Whether they want to try to get bonds or have a bond issue on the ballot, that would be a legislative decision for road improvements. But if they don't want to have a bond issue, that would be entitled to immunity.
Right. So if they say, we just want to be a dusty old town and we don't really want to expand our roads to keep up with all these people coming in, we'd rather they didn't come. That would be subject to immunity, right?
Long as they were able to explain that they took some affirmative action and considered this decision, whether it's by the city council, to make those decisions.
Council, let's say we have a coal-type process where we have a computer and we have factors and we plug in the data and it spits out 20 intersections. And we have $200 to spend as a matter of budgetary. And at that point, still using and looking at the computer, the same people that are in that room say, well, I don't think we can afford a four-way stop sign for all 20. So how about we do a blend of beacons and stop signs, and that's the case we have. It's not a matter of they've been identified, now it's goes to the next room over where we have engineers who will say, okay, now, does that matter that first decision, that what you would say is sort of an intersection-specific decision was made at the allocation point?
trying to understand your
Sure,
question.
sure. So we have scarce resources as government.
Right.
And we use a computer program to identify the worthiest of candidates for improvement. And we go a step beyond that. We say not only are we going to identify the candidates, but given the sum of money we have, we can only afford certain equipment at each of those. All right, so that same first stage, the computer stage, is that protected by Cole?
I think what Cole talked was the original decision, not the allocation of the funds. It was the original decisions on identifying what top 50 or 100 intersections, and I think in Cole it was top 20 decisions, and so it would not be protected by Cole. I mean, that's an operational decision and they would list their criteria or go further to make those decisions. They would have to come up with, or they would come up with another set of criteria.
Well, let's say it was tied directly to resource allocation, right? It wasn't an engineering decision. It was, we have $200, we can afford four four-way stop signs and 4 beacons. And so that is what led to the equipment that is there today. It wasn't necessarily an independent engineering stage. Is that protected by Cole?
Well, I think that becomes more discretionary. It's like location of bus stops, or in the school cases, that sort of thing. So I don't think it's protected by Cole, based upon that all these have been identified, and unless they show some valid criteria for making that the basis of that decision, it wouldn't be entitled to immunity.
Thank you, Counsel.
Thank you.
Good late morning, Your Honors. My name is Justin Ackerman, and with me at council table is Michelle Molinario, and we represent Yuma County in this matter. I think there's a fundamental disagreement in terms of how I view and opposing counsel views the immunity statutes applied in this way, and particularly the way Cole applies in this case. On the one hand, there's the decision based on the traffic report to improve the intersection. On the other hand, there is the decision to not improve this intersection after that change was made. It is the decision not to improve the intersection after the initial decision was made on what changes to improve the intersection that falls under Cole. It is the decision to improve the intersection that falls under various subparts of 12.820.01 that we argue is entitled to immunity.
So you view it as a affirmative versus negative distinction.
That's correct, Your Honor.
But where in Cole do you get that? The decision in Cole, again, seemed to me to be a resource allocation decision, not an affirmative versus negative decision. Nothing in Cole, for example, says the government is immune for every time it decides to do nothing. If that were the law, then a government could presumably claim that once it decides to undertake a project, it's immune from liability for those parts of the project it decides not to complete, but only subject to liability for those parts it seeks to complete. And that would be kind of anomalous.
I think if that's
a bunch of half-done projects. Right?
I don't think this court would want to encourage municipalities and various governmental entities to not take on projects in order to avoid immunity or to be subject to suit.
I don't think the Cole court said that was the touchstone.
And I'm not arguing that position. I'm arguing when a county decides under the second decision-making process here, just to be clear, when someone decides not to do something and that decision is based on in this particular case, the roadway analysis process that we've set forth in the record, and the decision and that decision in of itself is entitled to immunity, which is akin to what Cole had determined.
But why did they decide not to do something? They decided not to do something because they thought it was prudent, not because they couldn't afford it.
In this particular case, that's not. I disagree.
Okay, well, tell me why.
Sure. Let me back up then a little bit. The roadway analysis process in this case, like in coal, collected data, hard data on accidents that occurred within Yuma County. That hard data is then generated into a list, a top 50 or top 100 accident report list. It's undisputed in this record that the intersection at issue, post-2003, did not make that list.
Okay, but that's not really the question. I'm sure that after coal, it's very popular to create lists of priorities. I get that, and I understand why one would create lists of priorities. But then you have to tie the list to an actual policy or an actual decision. And here, I don't see that there's any evidence that the county said, we are going to do the top 10, and we're going to change those intersections. But we're not going to do this intersection because it's not in there. It seems to me that the evidence suggests that there's just a legitimate disagreement on whether it was safe to have no four-way stop.
I strenuously disagree with that, Your Honor.
Talk me out of that.
Sure,
Talk me off that ledge.
be happy to. The roadway analysis process, I have to keep going back to it because the way in which Cole determined immunity was it first found that the SIGWAR program was entitled to immunity.
I've read Cole so many times today.
I'm sure
you can tell from being here this morning how much we've read Cole. Talk to me about your record. That's where I need help.
Sure. Within the record, the roadway analysis process that we walk through specifically states, and it's undisputed because all of our statements of fact are undisputed in this record, that the top 50, top 100 intersections is what the county uses to determine which intersections it needs to look at for improvement. And it goes off that list. That is their fundamental governmental policymaking decision to use this list as part of its roadway design analysis process to evaluate which intersections it needs to improve based on its limited resources.
Do a traffic study of this very intersection?
It did do a traffic study of this very intersection.
So it spent money to study this intersection even though the intersection wasn't on the list?
That is correct. This intersection never made the list, but...
No, well, it's also correct that money was spent to do a study of this intersection even though it wasn't on the list. That doesn't sound very Cole-like to me.
Well,
Makes the list seem irrelevant.
It's for that very reason, Your Honor, that we've never directly argued that Cole applies to the 2003 decision to improve the intersection and applies to the decision not to improve the intersection post-2003, pursuant to the roadway analysis process because this intersection never made the list post-2003.
Okay. And so because it never made the list post-2003, you're saying that not a dime was spent on the intersection after 2003?
There was a slight improvement in 2008, but I'm not aware of any expenditure of funds for it. But under the Cole, I think that's here nor there, because Cole, the very same argument was raised in Cole, and opposing counsel had alluded to it, where certain intersections outside of the SIGWAR program were selected for improvement, at Desert Ridge and Mayo Clinic.
But is it even, do you therefore concede that a four-way stop would have been an improvement?
No, I do not, absolutely.
So the whole notion that we're not going to select this intersection for improvement is really kind of a red herring. If the four-way stop that's urged as necessary, in your view, wouldn't have been an improvement, or in your client's view wouldn't have been an improvement, that strikes me as a disagreement over design. It doesn't strike me as a fundamental government policy.
Well, let me point you where I think it does. Three provisions under 12.8.20.01 I think apply that show this is entitled to immunity. The decision in 2003 to pick a particular countermeasure. I would urge the court just to look at the plain language of 12.8.20.01, which...
Been doing it for quite some time now.
I bet. But at least for me to make the record, 12.8.20.01b provides a delineation of what I would consider safe harbor provisions of what constitutes fundamental governmental policymaking decisions. And within that safe harbor is the expenditure of funds, and that is exactly what occurred in this case.
Well, and that seemed to be, at least as I read Cole, at the heart of Cole. But was there ever a policy articulated or even formulated that said Boy, these four-way stops, they're expensive. We've got to watch where we spend those funds.
I think the court is focused a little bit too much on four-way stop versus some other traffic countermeasure.
I'm focused on the plaintiff's claims,
Sure.
which seem to be based on that.
In part, yes. I mean, their argument is that we failed to improve the intersection according to their standards, and a four-way stop has been the thrust of what they've argued.
Right. And that was, I think you're in agreement that actually the configuration of the intersection employed was more expensive than a four-way stop because it had lights. And
It did, yes. It was more expensive. It was.
so this had nothing to do with resource allocation. It had to do with a judgment as to how to configure the intersection.
Well, I don't think that the immunity statute is concerned with scarcity of resources. I think it's concerned with the expenditure of resources. When a municipality decides when to spend its resources, I think that's what the statute contemplates for immunity.
And they're unconnected?
I think they have been linked depending on the particular case, but I don't see anything within the immunity statute that says scarcity is the focus. It just simply states expenditure.
If we have
of funds.
limitless resources, why are we even?
Well, clearly, I'm sorry to interrupt. Clearly, municipalities, especially Yuma County being a more rural county, does not have unlimited resources, and that's to the very heart of this case. Is that there's only a certain amount of intersections that we have funds to improve.
There's no question that a governmental body with limited resources has to make decisions as to where to allocate them, right? And that's at the heart of subsection B.
Right.
We agree on that. Where I sort of fall off with you is how doing something that actually costs less relates in any way to allocating resources.
Your Honor, again, I know you're not going to like the answer, but the plain language of the statute to me, I think, solves the question, and that's Justice McGregor's concurrence in Cole. She said, I don't know why we're walking through this convoluted operational versus policymaking decision process to let the statute says expenditure of funds. That to me solves the question, and I agree with that.
But if Justice McGregor's concurrence were then taken to its logical extreme, it would result in a vastly different immunity structure than we have today, right?
I think this court should be concerned about immunity becoming the rule and not the exception. Absolutely.
I think that's a very fair concern, but we can't really go with Justice McGregor's concurrence and upset the apple cart of immunity when the Supreme Court hasn't authorized us to do that.
I think the limiting factor, though, is, especially in light of the facts of this case, when you have a legislative action to approve the expenditure of these funds, we're not talking about some low-level county employee's decision to buy pens and paper. We're talking about a county board of supervisors that, after receiving this recommendation from its chief engineer, reviews it, approves it, then solicits bidding processes for it, has to go and get a right-of-way for it. This is the four-way stop the flashing beacons on the minor approaches, and then pays for that. Mm-hmm. I think that clearly takes this and limits it, and I think this court can issue a decision under these facts that that's a legislative decision.
So if there's a legislative decision to redesign the intersection and the city council decides to design it with big trap doors into which cars can fall, are they immune from that because it costs money?
If that hypothetical ever occurred, I would say yes. Cole specifically says that a design of a roadway intersection that falls below the standard of care is still entitled to immunity under 12.82001.
And I understand that immunity is different from a defense. I get that. But then what do we do with the other case law that says once a city decides to act, it must do so in a non-negligent manner? Because those trapdoors sound negligent to me.
I think that the decision, though, is in implementing the policymaking decision in a non-negligent way. And so in this case, there's been a lot of discussion in the briefing about what the traffic study actually contemplated and what was actually done. Very briefly, I submit that the author of that study clearly says that the flashing counterbeaker measure was only meant to be done on the two-way approach, and I think that controls that issue, and I don't think it's a fact issue whatsoever. But the negligent implementation that is truly at issue in this case, if it existed in the record, would be this. It would be that the flashing counterbeaker measure was constructed too far away from the roadway. The flashing beacon lights weren't properly functioning. The stop sign that was supposed to be affixed to it was too small or too large. That's the negligent implementation of the countermeasure that was chosen. None of those facts exist in this record, and I think that would be negligent implementation if it existed in this record, but it doesn't.
So if the countermeasure that were chosen were, instead of a two-way stop, a one-way stop, so you only have cars traveling eastbound stopping, then the scope of potential negligence would be confined to how well that one-way stop was implemented, and not the question of whether a two-way stop might have been a much better idea.
You mean a four-way?
No, two.
I'm sorry, I don't
I'm
track
posing
them.
something of an absurd hypothetical.
Sure.
If the decision is, okay, we're going to have a stop sign going one way but not the other, eastbound but not westbound, and forget about northbound and southbound.
Sure.
We're not going to pay attention to those at all. Your contention is that it's only the quality of the implementation of that one stop sign that we can look at, not whether it would have made sense to have traffic stop in both the east and westbound direction.
No, I think whatever the decision that was approved, chosen, and selected by the legislature the legislative decision, which is the Board of Supervisors in this case, you can't negligently implement that decision. So in this case, the two-way stop with the flashing beacons.
But once the legislature decides to act, any parameters of its decision are automatically immune in your view.
So long as it's not a negligent implementation of that decision, and it's that decision.
It's actually an interesting question, so I appreciate your input.
Sure. Very quickly, I would like to also mention the third point on why I think the decision in 2003 is entitled to immunity, and I think that the decision that's made by the county engineer in and of itself is entitled to immunity as a fundamental governmental policy-based decision. And my reasoning for that is, the Myers case, the Cole case, Warrington, they all discuss that a formulation of policy characterized by judgment, discretion, weighing of alternatives, consultation with experts, and public policy choices is what defines a policymaking decision that's entitled to immunity under 12820A2. And that's clearly what Chief Engineer Patterson did. He evaluated, based on this traffic study, it presented 4 countermeasures, and they've repeatedly said that we've directed them to say push away from the four-way stop that was offered as a viable alternative countermeasure. Four-way stop, flashing beacons, traffic sight cones, and speed enforcement. And he chose amongst those based on pricing, based on traffic reduction, based on the public policy decision of whether we want to crowd these intersections with too many four-way stops, which the record's uncontested that we've provided expert testimony that too many four-way stops breeds disrespect for four-way stops, and it can be actually counterintuitive. So he's weighing all these issues and deciding we're going to go with this. I think that's entitled to immunity. The court in Armendariz clearly said that you don't need the formalized hallmarks of a legislative decision.
You just described a very elaborate and intensive analysis. What does it have to do with the list?
The list.
If all of those thoughts were given to this intersection, where does our priority list fit in?
The priority list fits into the fact that, first of all, the decision that we made in 2003 is independent of the decision not to do something elsewhere. I think immunity, if we get immunity for what we did in 2003, I think it extends all the way across the board to the action that occurred in this case. We presented this argument under Cole as a viable alternative, that if the decision not to do something post the improvement is equally entitled to immunity under the facts of Cole. The last point I want to make is on my cross spiel. Very quickly, the elements of Glazer, I think, are satisfied in this case. I think the trial court erred to the extent it did find any issue of fact, and his ruling didn't really articulate where he found there was an issue of fact, if there was one. But I think that their injuries arise out of the plan and design for improvement to the intersection. They've largely conceded this. The only argument they offer to the alternative is that their operational implementation argument, and that was squarely rejected by Glazer. I think the intersection improvements conform to generally accepted engineering standards, and this is focused on the 2003 improvements. We have undisputed expert testimony that says that it was almost word for word of the statute. To install Flashing warning beacons on the minor approaches was made in conformance with generally accepted engineering and design standards in effect at the time of the preparation of the plan or design. That's our index of record 65, which is our statement of facts, paragraph 135. Their expert offers absolutely no testimony that contradicts this. The best he can actually come up with, it, which is in his depositions, that he says, I'm not saying it's unreasonable, there's secondary or tertiary measures, which to me is a concession that if something's secondary or tertiary, it still conforms with generally accepted engineering standards. He doesn't provide a single opinion that specifically says the intersection itself does not conform with generally accepted engineering standards. So I don't think there's any issue of fact whatsoever within the second element of Glazer.
Where do generally accepted engineering standards appear in the law? I understand they're very useful for fact, but we still live in a world dominated by the Markowitz case. I mean, why is that sort of elevated to being of legally dispositive significance?
I mean, I'm going off of the way in which Glazer has interpreted 12.820.03, where it has said the statute itself says that the intersection needs to conform with generally accepted engineering standards. I don't know if that particularly answers your question, but that's why that becomes important in my head.
It's helpful. I understand why you're saying what you're saying now. But you're now suggesting that there is no ambiguity in the expert reports.
I've always argued that, Your Honor.
That's okay.
And finally, I would argue that the intersection, which is the third Glazer element, was not unreasonably dangerous. But even if it was, we gave reasonably adequate warnings, which is all we were required to do under the statute to safeguard the intersection. I would point to the court that what's reasonably safe takes into consideration that certain minimal expectations that travelers follow the rules of the road, which is what the Supreme Court has said in Colburn. And, there's clear violations on both sides of the drivers in this case, of one, excessive speed, and two, not yielding to the right-of-way of that person. And if both people had followed the existing traffic countermeasures that existed at the intersection on the day of the accident, it never would have occurred. And finally, we gave every possible reasonable warning we could have given. We had 500 feet before the intersection saying, stop sign ahead. We had the actual flashing warning beacons. We had an oversized 4 feet stop sign, which is just truly massive. And we had underneath that our warning saying cross traffic does not stop. I believe I have 9 seconds. Unless you're going to give him more time, I'll finish.
Thank you, counsel. It's been a long morning. Thank you for your argument. We appreciate your time and your attention to what we needed to hear today. We are going to take the matter under advisement this time, and with that, we are adjourned. Thank you.